There we go. So good morning, everyone. Happy Thursday. I just want to thank everyone for joining us today for another EIA Lunch and Learn. So today we'll be talking about rules and regulations, advocating for people with disabilities within the workplace. So I see a couple new faces, which is pretty awesome. Again, we're just a community that wants to band together and grow together one step at a time. So definitely happy to see some new faces within the crowd, or some of you don't have your cameras on, but some new names there. So that's awesome. So today we have a guest speaker. She is a workplace lawyer. And so we have today Kate Engel, who's going to be giving us a whole bunch of valuable information for a lot of the organizations that we have today and businesses. So definitely, I'm going to quit talking now. I'm going to pass it over to Kate. So everyone, this is Kate.
Hi, everyone. So I'm Kate Engel, and I am a lawyer here in Edmonton, Alberta. I've been practicing for almost about 10 years with a focus really on human rights in general, and also for the past couple of years with a focus on human rights in the workplace. So I believe I have a lot of valuable information and knowledge to help you better understand human rights in the workplace. And I prepared a PowerPoint to assist everybody in following along, assist me as well, and keeping on track. So I'm going to share that. Okay. All right. So so human rights in the workplace is what this presentation is about. Okay, and just, brief introduction again. So I'm Kate. I'm an employment lawyer, and when I was preparing this presentation, I was thinking, okay, what would I like people to walk away knowing about human rights in Alberta? And so I really, at the end of the day, want all of you to walk away with a better and more complete general working knowledge of what the Alberta Human Rights Act is, when it can be triggered in the workplace, and what are your responsibilities as employers when you are assisting a person with disabilities who's employed and needs some accommodation. And I'll talk about what accommodation means and what are the legal requirements surrounding accommodation as well. I'm also going to talk just very briefly on the Employment Standards Code. So the Alberta Human Rights is the primary piece of law in Alberta that relates to disability rights in the workplace, but there's a little bit in the Employment Standards Code that talks about that as well. So I'll just talk very, very briefly about that near the end. Now, in terms of questions, I don't mind if people want to ask me a question as I'm speaking. And I think that would probably be helpful because I will be talking about legal tests, which in this context can become a little bit confusing. So I want you to understand, what I'm saying and the meaning behind it. So if anything is unclear, you have a question about what I'm talking about, please interrupt me. You can just start talking, that's fine. And I will stop and try my best to answer your question. And really, if you have any question at all at any time, please interrupt me. Now, I might let you know that I'm probably going to answer your question later on in the presentation. So, sometimes that happens where people have questions that I'm going to answer later on. So I might just shelf your question and revisit it once we start talking about that topic, the topic that your question relates to. So basically, please interrupt me. I won't be insulted or upset. I want to make sure that everybody is getting the best understanding from this presentation. Okay, so, all right, so I'm a lawyer, so I have to give a disclaimer, of course. So this is not legal advice. I can't give legal advice to anybody here today for reasons that I won't get into, but yeah, so I cannot give legal advice. So I can't comment on specific scenarios that might have arisen in your workplace, but I can answer general questions about the topics in this presentation. That would be fine. I also want you to know that this is not a comprehensive course on issues relating to human rights under the Act. And when I say the Act, I'm talking about the Human Rights Act. So it's not a comprehensive course. There's lots of different issues that can come up under the Act, that legal issues that I'm not going to go over. So just be aware of it. That really, I just wanted to provide a general overview of the really core issues that I think employers need to be aware of. And yeah, so this presentation, it's focused on an explanation of the law relating to the Act. So it's not going to talk about practical applications of the Act, so how to apply the Act in your specific workplace. Now, I may be okay with answering questions about maybe hypotheticals. If you have a hypothetical to give to me, I might be okay with that. And by that, I mean like an example of a situation that might arise in the workplace. So I probably would be okay with talking about that and how the Act might interact in that situation. But other than that type of thing, I'm really just going to focus on explaining the law to all of you. And then lastly, I want to draw everybody's attention to the Alberta Human Rights Commission website, because this website it's amazing. It has a wealth of information on it. It has full PDFs explaining the law in a lot more detail than I'm going to do today. So I would encourage everybody to go over there, look at their resources. They're very, very, very helpful. Okay. All right, so I have an agenda here. Oh, I have part one. Should have deleted that. I wanted to take out the parts because, and the reason why there's parts is because this might, if I can't finish everything today, we might have a second part. So just ignore part one on my agenda there. I wanted to delete that. But anyway, the overall agenda. So I'm going to talk about what the Human Rights Act is. I'm going to talk about what is discrimination under the Act, because we might have some non-legal understanding of what discrimination is, which may not be the same as the legal test for discrimination. I'll talk about who's protected from discrimination, what sections of the Act apply to the workplace, so what sections you need to be aware of, what is the legal test for discrimination, what are the justifications for discrimination, so what are the defenses really to discrimination if it's proved that there was discrimination, what types of defenses can an employer raise in response to that, and legal tests relating to that. And that's really going to be the most complicated part of this presentation. And then I'm also going to talk about the process that is followed if somebody has launched a human rights complaint against an employer, what the process looks like for processing that. How does the commission process that? And the commission is the body that receives these complaints, investigates them, and processes them. So when I say questions as well, but as I said, you can ask me questions in the middle of this presentation. That's fine too. Okay, so what is the Alberta Human Rights Act? Now, we have, I'll preface this by saying we have two types of law in Canada. We have written law, which is made by our government, so pieces of legislation. We also have what's called the common law, which is law that is made by judges, and tribunals like the Human Rights Tribunal. Um, so we have courts and tribunals who also, in their decisions, make law. So, for example, in this context, we have the tribunal we have decisions from the tribunal, and they have interpreted the Human Rights Act, and they've expanded on what's in the written law through their decisions, by telling us, okay, so we know that, for example, certain types of actions by employers against people with disabilities are illegal, but how do we figure out when an action is illegal? And so the tribunal will expand on that through their decisions and tell us more about what the law is relating to that. But back to the Alberta Human Rights Act. So every province has their own human rights legislation, has their own written act relating to human rights, including as it relates to human rights in the workplace. And just so you know, if you happen to be a federally regulated employer, or if you work in an Indian band, for example, then any discrimination that happens in that context is governed by the Canadian Human Rights Act. Now, most of the legal tests that I'll be explaining today equally apply to the Canadian Human Rights Act. So the Canadian Human Rights Act, it's written differently than the Alberta Human Rights Act, but really its application is pretty much the same. Not exactly the same, but pretty much the same. So if you're this type of employer, this will still be useful for you to hear this presentation. Okay, so Alberta Human Rights Act. This is our act in Alberta relating to protecting people against discrimination. And the Alberta government website describes the act as affirming basic human rights and prohibiting discrimination in various contexts in Alberta. And of course, this includes in the context of employment. So that's the overall purpose of the act. The act also creates the Human Rights Commission, which, as I said previously, is the body that receives complaints from people and processes them, and also the tribunal. So the tribunal is the decision-making body. So if a complaint goes to a trial, the tribunal will hear it, and the tribunal will make decisions on whether there's been discrimination, and if yes, what to do about that. So the act also creates these two bodies. And I'd encourage everybody to read the act. It's not very long, so it's fairly easy to understand as well. Some of these legal, some legislation's complicated, but this one is fairly easy for a person without legal expertise to understand. Okay, so who's protected from discrimination under the Act? So the Act tells us that people with certain personal characteristics are protected from being discriminated against. So this includes age, religious beliefs, color, gender, and so on. So all of the characteristics that are on this page here. And of course, physical disability and mental disability, which is pertinent to this discussion. Okay, so what is physical disability? What is mental disability? It has a legal definition under the Act. And when you read the Act, you'll see Section 44 defines physical and mental disabilities. Mental disability is any mental disorder developmental disorder, or learning disorder, regardless of the cause or duration of the disorder. Physical disability, so it's physical disability under the Alberta Human Rights Act is pretty broad, which I think is good. We have other acts, for example, in BC, where it's a little bit more restrictive. So Alberta doesn't really have that. It means any degree of physical disability, infirmity, malformation, or disfigurement caused by bodily injury, birth defect, or illness. And then there's a list of all the possible disabilities that may arise, but it says without limiting. So that means it's not a closed list. It can include many other things. So you may not be sure if an employee has a disability that is covered by the Act. So if you're not sure, and I'm going to talk about this later on, it's always best to inquire with them. In fact, there's a legal duty to inquire with them. Now, of course, this only arises if there's some issue in the workplace that's affecting that person's ability to perform their duties, or if they're requesting accommodation, something like that. But if you're not sure if they have a disability that's covered by the Act, you actually have an obligation to ask them, inquire with them about that, and learn more about that. Of course, because you need to know that in order to properly accommodate them in the workplace. So just be aware of that. And it's helpful, I think, to know that the definition of the Act really is broad. So it could include a wide variety of things. So you may not think it's covered by the Act, but it might be. So just keep that in mind. I do have a note here that normal ailments like the flu or common cold are not typically considered disabilities, but I never say never. So it really just depends on the circumstances of that specific employee. And when you're in doubt, of course, always inquire with the employee about the extent of what they're experiencing. And if you can, get legal advice on whether that person has a disability considered that's protected under the Act. Okay, so as I mentioned in the beginning, there's sort of we as a sort of in the non-legal world, if I can say it that way, we may have particular idea of what discrimination might be, when it arises, and so on, which may not be the same as what discrimination is under the Act. Discrimination under the Act is very specific, and 3 factors must be satisfied in order for a complainant, so complainant being the employee, to prove that they've been discriminated against. And under the Act, the complainant has the initial onus to prove what's called a prima facie case of discrimination. And once they do that, then the onus shifts to the employer to justify the discrimination in the workplace. So, and I'm going to talk all about justification, but just to talk about the legal test for discrimination. So the complainant, as I said, has proved 3 things, and I have a case here that I've cited here, which talks about the test. It's very well established. And so the factors are: number 1, the complainant has a characteristic that's protected from discrimination. So you'll recall that I just discussed these personal characteristics. So that's what the first part of the test is talking about. First, you got to
Sorry,
establish.
sorry, Kate. There's
Yeah.
actually one question that popped up in
Oh,
the chat right
yeah,
here.
sure.
And it's from Diana from Accessibility for Everybody. And so the question is the Alberta Human Rights Act susceptible to change by the provincial government? And follow up to that is how could they potentially change this act?
So, yes, the act can always be amended by the government. So, in order for that to happen, now I'm not, um, can't recall the exact process, but that an MLA would have to introduce a motion in the legislature to amend the Human Rights Act to add or remove something, and then there'd have to be a vote on it, and if it passes the vote, then it would be amended. So that's a very simplified summary of that process. So my answer is yes, it can. And how the government has to an MLA from the government would have to make a motion to do so, and that motion would have to pass in the legislature. And back, I believe in 2015, I may have that year wrong. So gender identity was added to the act. So it was changed to include gender identity. Prior to that point, it had not been in the act before. And how that happened is an MLA would, made the application or motion, and then it was passed, and then the act was amended. Does that answer the question? Can't see the chat here, so, oh, here we go. Okay, great. Yes. Okay. Okay, and thanks for that question. Okay, so back to the test for prima facie discrimination. So the first factor that has to be satisfied is that, first of all, you have to have a characteristic that's protected by the act, because if you don't, well, then it's a non-starter, at least under the Human Rights Act. You might have a recourse elsewhere, but at least under the Human Rights Act. So then the second component of the test is that the complainant, which in this case would be the employee, must have experienced an adverse impact. So some negative impact must have happened to them. And in employment context, that could be maybe they weren't hired for a job because they had a disability. Maybe they were fired because they had a disability. Maybe they were disciplined for reasons connected to their disability. So, for example, maybe they weren't performing well because they're dealing with their disability, and because of that, they're disciplined. Maybe they're being harassed or bullied, things like that. So if there's a negative impact, then that the complainant can prove, then the second factor will be satisfied. And then lastly, the protected characteristics. So in this case, I'm just going to say the disability, because disability is protected under the act. The disability was a factor in the adverse impact. So there has to be a connection between the disability and the negative impact. So back to my example of perhaps an employee is not able to perform well in their job because they're struggling with their disability, and the employer then disciplines them, for example. So there's a clear connection there, because the reason for the poor performance is influenced by the disability, and then the poor performance results in discipline, or performance improvement plan, something like that. So there's a connection there. Now, that's not the only example, but it's just one example to try to put in perspective for everybody. So that's the third factor. So when these three factors are met, then the burden shifts to the employer to justify the discrimination. If the employer cannot justify it, then there will be liability found under the act. And as I'm going to talk about later on, the tribunal can award all sorts of things against the employer if there's discrimination. Okay, so I want to talk about when discrimination is justified, but it's first really important for everybody to know what specific sections of the Act talk about workplace discrimination and what is prohibited under the Act in the context of the workplace. Okay. Okay. So I like to think of the Act as protecting people with disabilities for the entire lifespan of an employment relationship. That's how I like to frame it in my mind. So really from birth to death. So it protects as early on as an advertisement being put out. So a person doesn't even have to be hired yet for an employee to be protected under the Act. It protects during the hiring process, it protects during the employment relationship, and it protects people at the end of the employment relationship. So Section 8 of the Act, and again, I really encourage you to read these sections because I'm just kind of summarizing them here. So Section 8 prohibits employment applications and advertisements from expressing a limitation, specification, or preference indicating discrimination on the basis of disability. So an ad for a job cannot unjustifiably, and I'll talk about justification later, cannot unjustifiably communicate a preference for somebody who is not disabled. And Section 8 also prohibits requiring applicants to furnish information about their disability if it's unjustified. So an employer cannot be asking all sorts of questions about whether a person has a disability, what the symptoms are, etc., if it's totally unrelated to any role, obligation, duty connected to the position. And I'm going to talk about that later and what standard applies to that. So then secondly, so we also have section 7(1)(a), which prohibits people from refusing to employ someone for reasons connected to their disabilities. Third, section 7(1)(b) protects people during the employment relationship. So it relates to any terms or conditions of employment. And not only does that relate to conditions like in the workplace relating to carrying out the job, it also relates to harassment and bullying. And I really want employers to know that even if management isn't the one that's doing the bullying and harassing, if management is aware of it and they don't do anything about it or they don't take adequate steps to address it, then the employer can be liable. So I really want to emphasize that because I see a lot of times employers, in cases of harassment and bullying, employers saying, well, I had no idea, or I wasn't the one who did it, so we're not liable for it, which is not really a defense. So be aware of that. Fourth, Section 7(1)(a) protects people from being terminated for reasons connected to their disability. So these sections, as I said before, really show that it's employees are protected from the very, very beginning, early on stages, up until the very end.
Sorry, Kate, just one
Yes,
quick question here.
sure.
For section 7(1)(a), where it talks about prohibits refusing to employ someone for reasons connected to their disabilities,
Mhm.
how would, I guess, how would the potential candidate, um, I don't know how to word it, like how would they know if that was the case from the employer side that they were not chosen or selected because of their disability?
Yes. So I will say that 7(1)(a) and also, yes, 7(1)(a) it's hard to prove because usually, because employers aren't coming out and saying, oh, well, I'm not hiring you because you're disabled. Now, that's not necessarily required for the employer to explicitly state it. If there are circumstances surrounding the refusal to employ that the person is aware of, like, for example, just off the top of my head, okay, let's say the employee becomes aware that they didn't get a job. Instead, a person who was less qualified or underqualified got the job over them. That person is able-bodied. And the only difference between, or sorry, not the only difference, but the person who didn't get the job is disabled. That might be very suspicious, and it might be enough to have the commission accept the complaint and investigate it more. And I will say that in the investigative process and in the complaint process, there are obligations to furnish relevant documentation. So it could be that perhaps the complaint's accepted just based on this sort of suspicious circumstance, and then through the complaint process, more evidence is revealed through this production sort of obligations. So that's my first response to that first example. Another example, I mean, maybe, like I've heard of this before, where somebody doesn't get employed and then they hear after from somebody that they talked to the employment hiring person, and the hiring person said, oh yeah, well, we don't hire people like that. We don't hire people with disabilities, or we only hire normal people. Like, I've heard that, which is offensive. But anyway, yeah, so I've heard that sort of thing. So that type of information could be used, right? I see a question, but I'm just going to finish my thought on this. Now, I'm giving some examples here of what we call sort of circumstantial evidence, which is like there's a bunch of little circumstances surrounding the discriminatory act, which in and of themselves do not point to discrimination, but when considered together, make it more likely than not that, for example, in this case, the reason why somebody wasn't employed was at least for one reason due to their disability. So if you can collect those circumstances, you might have enough to have your complaint accepted. That last thing I'll say on this is it's difficult. Like, I will not lie to you guys, right? It can be very difficult because employers, again, aren't coming out and saying this because they know that if they do, well, then it's going to be a human rights complaint, or, it's going to be some other legal action. So it is hard to prove. That's just the reality. I hope that was helpful. I kind of went a little bit I took a meandering route to answer that question. So I hope that answered your question.
No, it definitely does. And I think we just had one more question from Diana. You can go ahead, Diana.
Yeah, so from my understanding, as an employee, you do not have to disclose your disability. But when you went over one of the previous slides, it said something about having to know what the disability is to provide accommodations. Can you speak a little more to that?
Yes. Now I can speak to it now, but I do plan to get to it later. I think later this question that you have will be fully answered. So if you're okay with that, let's put your question on hold. And after I talk about that topic, if he's still not clear for you, you can ask your question. I see a heart, which I'm going to take as yes.
That would be fine.
Okay. Yeah, okay. Were there any other questions before I move on, just about what I've talked about so far? I don't see anything. Okay, here's a couple of things I think is very important for employers to know. Does the disability need to be the only or main factor causing the adverse impact in order for it to be discrimination? No, it doesn't. It doesn't even have to be the main reason or the sole reason or the overriding factor. It only has to be one factor. And where I see this coming up a lot is in terminations, where there's a laundry list of reasons for the termination, and there's one reason that's not even the biggest reason that can be linked to the person's disability. So for example, performance issues, or I've seen as well employers citing, well, this person, works from home too much. And the reason why is because they need, to work in a distraction-free environment. That's why they're working from home so much. So I've seen that happen before, where there's all these lists of reason, and then we have one reason where you can link to the disability, and if that happens and that influenced the reason to terminate, for example, then that can be enough to prove adverse impact. So be aware of that too. I think it's important for employers when they're deciding whether to discipline, when they're deciding whether to terminate, to think about, okay, are the reasons why we want to take this action, can we connect it to a disability? And if the answer is yes, then you need to move on to whether it's justified. So, and I'm going to talk about that. Don't worry, I'm going to get to that. Now, the next point that's very important for employers to know is that whether you intend to discriminate against somebody is irrelevant. It doesn't matter if you intend to discriminate against somebody. The law is very clear. What matters is the effect of discrimination, not whether there is an intention to discriminate. So that's really important. Okay, I see a question. How does the Human Rights Act apply in safety-sensitive workplace, particularly regarding pre-employment drug and alcohol testing? If drug or alcohol addiction is considered a mental disability, would it be considered discrimination to refuse employment to candidates who test positive? Yeah. So I think this question will be answered when I talk about justification for discrimination, because there are circumstances where there is a justification to not employ people who are suffering from drug or alcohol addiction, and that relates to safety sensitive workplaces. So I think that I will answer that question when I get to that discussion. And if I don't, please let me know. Okay, I think that Diana, this will answer your question. So what if the employer doesn't know about the disability? Well, so lack of knowledge can be a defense, but that is only if there are no circumstances in which the employer reasonably ought to have known that the employee could have been experiencing a disability affecting their employment. So obviously, if an employee tells you you have a disability, well then, or they have a disability, then the employer's not going to be able to say, well, we didn't know about it. So I'm not going to talk about that. What I'm going to talk about is when there's more indirect circumstances that give rise to this duty to make further inquiries. So if an employee is acting in a way that gives rise to sort of like I'm going to call it like a suspicion or a reasonable suspicion that there's something more that's influencing what's happening with them, specifically mental or physical disability, then the employer must make reasonable inquiries with the employee. I have some examples here. So, for example, an employee continues to miss work, so they're having some chronic absenteeism due to having to attend doctor appointments. Prior to taking negative action against the employee, in this case, I would say the employer has a duty to inquire with the employee about whether they have a disability or, generally what's going on with them and whether they need accommodation in the workplace. And so the circumstance in this case is, of course, going to a doctor's appointment. That would raise a flag for the employee to first inquire further before taking negative action. Another example, and I recall reading a case that was kind of like this by the tribunal where they found in similar sort of circumstances that there was an obligation to make further inquiries with the person. So this example is the employer sees the employee constantly crying in their office, having panic attacks, that sort of thing, needing numerous breaks as a result. And because of the numerous breaks, the employee is getting behind in their work. So a reasonable person would know that the employee might have some mental disability affecting his ability to get work done on time. So the employer then, before they take negative action against them, has a legal obligation to inquire with them about what's going on with them, whether they have a disability that needs accommodation. Now, the employer's limited to asking only for reasonably necessary information, which usually includes only enough medical information that allows the employer to investigate possible accommodations. And it's not always required that there be a diagnosis if the diagnosis is not required to accommodate the person. So perhaps the employee discloses, generally their symptoms, issues going on with them without disclosing a diagnosis. That might be enough. Now I say might because all of these sorts of cases, they turn on their own individual facts. So each case is different and is assessed on their own. So it's a case-by-case analysis, depends on the circumstances. What's reasonably necessary in one case might not be reasonably necessary in another case. One case might require disclosure by the employee of a diagnosis. One case may not. It really depends, and it can get tricky and complicated. So if you're in the situation where you think you need more information and you're getting a refusal from the employee, you probably want to talk to a lawyer about what you should do next. And I'll also note here that the employee does have an obligation to cooperate with the employer. So if for example, an employee struggling in the workplace, the employer thinks, okay, there may be a disability here at play. The employer then inquires with the employee, and the employee says, I'm not telling you anything. I'm not helping you with this process at all, but you need to accommodate me. In that sort of situation, probably the Human Rights Tribunal is going to say, well, how could they have when they didn't have enough information to investigate what would be reasonable accommodation? And in that case, the tribunal would probably dismiss the complaint. So it's important for employers to know the employee cannot just sit back and not cooperate with you. They do have to cooperate with you, but only, again, giving just what is reasonably necessary information. The duty to inquire, it's very important. Failure to inquire can be fatal to defending a complaint. So it may be that, you know, hypothetically, it could have been impossible for you to accommodate the person, but if you didn't even inquire with them, you didn't take much steps to investigate what's going on, then that can be fatal to your defense. So it's very important. Diana, does that answer your question?
Yeah, so also from my understanding, and you might be getting to this, but there's also a duty to accommodate by the employer as well. And from my understanding, again, you don't necessarily have to disclose the disability as long as you can describe what accommodations are needed. Can you clarify that?
Yes. Now this is tricky because um, it depends on the circumstances, but I think I would say that if you don't have some sort of medical documentation backing it up, and I think that that might be a struggle for an employee if they don't have any medical documentation. Now, I'm not going to say that that would be required in every single case, but I think it would be much more difficult to point the finger at an employer for failing to accommodate if they're not producing some sort of medical information. So that's my one comment. And I also want to emphasize, unfortunately, there are limitless scenarios that could happen, which all are distinct, and it's impossible for us, right, to anticipate, to give a concrete answer on, okay, what has to be disclosed in every single case. I can't give that answer. It's just what's reasonable in the circumstances, which I know is not a very satisfying answer, but you just need to, in each case, take a look at the information you have and really consider, okay, do I have enough to proceed with the investigation into accommodations? I always recommend getting legal advice too. That's a good step because the lawyer will be able to help you determine if you're meeting that legal standard. I hope that helps.
Yeah, and I'm like I said, I'm not sure if you're planning on talking to about duty to accommodate, but can you elaborate more on that in the specifics of like the Alberta legislation?
Yes, I'm going to talk about that in a lot of detail. So don't worry about that. Now I see I have 7 minutes left. Okay, I'm just gonna see here. Okay, can I just go over my last couple slides and then we could move on to the accommodation discussion at the next session? Yeah, okay. All right. So if the employee passes this initial test, so the 3 factors that I talked about, if they prove those, then onus moves to the employer to justify the discrimination. So this is section 11 of the Act, which talks about contraventions being permitted if they're reasonable and justifiable in the circumstances. And in this context, the employment context, a contravention will be reasonable and justifiable if it's based on a bona fide occupational requirement. So bona fide just means a real, genuine, or sincere requirement. So to summarize this, it means if there's some requirement of the job that requires that some people be discriminated against, it's a real, genuine requirement, and there's no way in which that requirement can be avoided without causing what's called undue hardship to the employer, then likely the discrimination is going to be justified under the Act. And I'm going to go over this test in detail. So let me see here. Okay, so I can start this now but maybe we want to wait because I think I've talked about the first part, so the prima facie discrimination, what the complainant has to prove, duty to inquire by the employer. And then the next kind of chunk is going to be, okay, so once the complainant proves that, what does the employer have to prove in order to defend the complaint? So I think probably be better to wait, seeing how I have 4 minutes.
Yeah, I think that would be probably best, I think.
Okay, now, if anyone has questions about what we did discuss, I could answer them. Let's see. If an employee is working virtually. So okay, so the question is if an employee is working virtually for a business that is American, would the Alberta Human Rights Act still apply to them? I would want to look at the employment contract because the employment contract with these sort of international agreements, usually there's some clause that says, and it is agreed that the employer and employee are bound by the law of such and such state or such and such province. So if there's a clause like that, then you would go with what's in the employment contract, so long as it's enforceable, which is another issue I'm not going to get into today, but look to the contract first. If the contract is silent, then I would look to where the business does their primary, where the primary location of the business is. If they are operating mostly out of the States, probably it's going to be the American law. You know, if they have offices in Alberta and the employee works for an office in Alberta, might be the Alberta Human Rights Act. Now, this is a legally intricate question too. It really depends. So, of course, my fallback is get legal advice, get a lawyer to look at the contract and talk to you about your circumstances. Okay, looks like I clarified that. So, yes, you're welcome. Anything else today? Doesn't look like it. Okay. Yes, you're welcome. My pleasure.